Bill. A short while ago, I spoke to a Liberal MP for North Sydney, Trent Zimmerman. Trent Zimmerman, thank you very much for your time. Now, the government in the last week did get through both the ABCC legislation and the Registered Organisations Bill, but you'd have to say at quite a cost. I spoke to Labor's Brendan O'Connor yesterday, and he seemed relatively pleased with the outcome, particularly the provisions forced on the government over procurement and also the 2-year delay in the introduction of a building industry code. It's certainly the case, is it not, that the final outcome agreed by the Senate has undermined what the government wanted and what the Trade Union Royal Commission recommended?
Well, I think that what we've seen is the government delivering on what was a key election commitment. Now, in this new parliament, obviously pragmatism and compromise is essential to get that agenda through. And the government's demonstrated, without any help from the Labor Party, that it's prepared to work constructively with the Senate to achieve what are really important reforms for the Australian economy. And you've got to recognise that the construction and building sector employs something like 1 million Australians, and it's been a priority for us to improve productivity and to end the horrific lawlessness and thuggery that's been a hallmark of the construction sector for too long.
But if the union, the CFMEU, has got significantly what it wanted, particularly in regard to the building industry code being put off for 2 years, that's not quite the kind of victory that you were suggesting when you went to the election back in July.
Well, I don't think we should make any mistake about this. The Labor Party and the union movement have fought these reforms tooth and nail ever since the government announced their intention to re-establish the Commission. So while they're trying to find some silver lining on the cloud for them, what is the case is that our reforms have remained essentially intact. But of course, dealing with the new Senate as we have to do and respecting the outcome of the vote and the outcome of voters, we've been prepared to pragmatically compromise.
Another sensitive issue coming up at the Council of Australian Governments meeting on Friday, the Prime Minister and the state and territory leaders, the question of Adler shotguns will be discussed, whether or not the ban on imports should be lifted. This is a very sensitive question. Would you like to see the ban on imports retained?
Well, what we've said all along is that the states have to come to an agreement as to how these shotguns should be classified, and the ban on their imports will stay in place until that agreement is reached. The states license guns in Australia, and that's why they're the ones that have to make the determination on how they should be classified. But any breakthrough which resolves this issue would obviously be welcome, but until that breakthrough occurs, the ban on importations will stay in place.
It is a difficult issue for the coalition. It was a factor in the Orange by-election in New South Wales, along with the question of the ban on greyhound racing, of course, and also council amalgamations, saw the government's vote in that seat collapse. There is a danger that if you retain the ban, that similar disaffection would occur more broadly, not just in New South Wales, but elsewhere.
Well, the National Firearms Agreement, which was implemented by the Howard government, I think is one of this country's most important achievements. And the resolve of the current government, the Turnbull government, to maintain the National Firearms Agreement is absolute. We saw arising from that awful massacre at Port Arthur, I think, a great resolve to make sure that we didn't have the type of firearm issues which have so blighted, for example, the American landscape. So what we are clear about is maintaining that agreement. Now, under the agreement, these type of guns were classified as Category A, but when the government received evidence that an enhanced gun, if I can put it that way, a larger magazine version of the Adler was likely to hit our shores, we put the importation ban in place and said that the states would have to look at the appropriate classification. Now, I've seen the media reports that New South Wales is looking at supporting Classification D. That is a matter for the states, but I would note that that is the tightest and toughest classification and would mean that the guns are only available to people like, for example, those that are engaged in shooting feral animals as part of government programs.
Indeed, talking about the minor parties more broadly beyond what we saw with the shooters and fishers in Orange, there's no doubt that at the last election, where minor parties and independents got something like 23% of the vote, we've seen polls recently suggesting that that is now as high as the mid-30s. In the case of the Senate, the minor parties put a few runs on the board, if I can put it that way, with amendments to not only to the union legislation but other matters like backpacker tax as well. How worried do you think the major parties should be, specifically the Liberal Party, about the signs of increasing incursions by the minor parties?
Well, I'd say two things. Firstly, in relation to the Senate, it is exceptionally unusual, in fact I think only for one term in living memory, that a government of the day has had a majority in the Senate, and any government that wants to actually deliver results has to be prepared to be pragmatic and work with those that hold the balance of power in the Senate. We saw that from John Howard on when he negotiated the deal with the Democrats in relation to the GST. And what we have shown is that we've been able to deliver what are some really important reforms for this country by working with those crossbenchers and respecting ultimately the voters that supported them. In relation to your broader point, of course every political party has to have its eye on what the community is feeling. We live in a democracy and that's an important part of it. And that's why we're squarely focused on what we think are the most important issues for Australia. And that's about creating the jobs and the security and the prosperity that all Australians want themselves and, more importantly, their children to enjoy in the years ahead. But the other thing that I would say, and I note there are some that are saying that maybe the Liberal Party needs to be more like One Nation and the like. Ultimately,
that's Corey Bernardi, of course. Yes.
We are in this business because we believe in a certain set of ideals, and whilst you need to be pragmatic, I also think that voters want parties to stand for their beliefs, and that's really important for the Liberal Party.
One other issue before I let you go, and that is the forthcoming Senate inquiry into the Attorney General's behaviour in relation to the Bell Group and demands by the West Australian government that its coffers be put ahead of the Australian taxpayer. Of course, failed when it got to the High Court. If, as George Brandis suggests, there is nothing to see here, why won't the government dispense with legal professional privilege for the then Solicitor General, Justin Gleeson, so that he can recount what occurred in critical meeting with the attorney, which if there is, as I say, if there is nothing to see here, surely there's no problem, particularly given that the case that it involved, the litigation, is now well and truly over.
Well, I think what we've seen during the last week is the Labor Party at their worst in trying to besmirch the reputation of government ministers. They went on a major fishing expedition and couldn't even land a tadpole in relation to this. The facts are simply these. The Commonwealth acted, the Attorney General acted on the advice of the Solicitor General to intervene in this court case, both with the ATO as a party but also the Commonwealth itself as a party. And so at all times the Attorney General did exactly what he should do. He tested the advice, he considered options, and he ended up taking the advice which put the Commonwealth's interests first. That was namely to support the ATO's action and also to support the broader Commonwealth's action on constitutional issues. And of course, as you've just mentioned, the High Court essentially found in favour of the position the Commonwealth was putting forward. So what we've seen, I think, is really quite an unwarranted attack on George Brandis, who did put the Commonwealth's interests first, as is his responsibility, and was successful in doing that.
But why shouldn't the public know exactly what transpired? There was $300 million of taxpayers' money at stake here. The case was manifestly unconstitutional and also in breach of the corporations law, would have had huge ramifications for the Federation and for the Commonwealth had the ATO not been able to intervene. Why not let the public know what happened, why initially George Brandis was not persuaded that the government should intervene, and only after this conversation with Justin Gleeson that it should.
Well, I'd start by making the point that across all sectors of the economy and government, the principle of legal privilege is an important one. We accept that any client should be able to talk to their legal representation and have that confidential. I note that the Bell Group liquidation is yet to be finalised, so one has to look at the issue of whether disclosure of legal advice could have implications on potential future actions that parties might take. But the bottom line comes back to the fact that the Attorney General did what he was meant to do. He tested the different advice he was receiving, he tested the different options, he got advice from the Solicitor General in relation to the Commonwealth's role, and having tested that advice, he took that advice. And the result is, as we've seen, the Commonwealth, the ATO, prevailed in relation to the arguments that they mounted in the High Court. So it's been a proper process, and I don't think the Labor Party has been able to establish any case that the Attorney General has to answer.
Trent Zimmerman, as always, appreciate your time. Thank you very much.